Hello everyone, and welcome to the Firearm Firm channel. In this video, I'm going to be discussing a self-defense case out of Florida that our firm has been handling for the last 2 years. Now, this case gained national notoriety and was featured on many national news stations due to our client being a former professional fighter and world Muay Thai champion. Last week on April the 19th, 2023, a Florida judge determined that our client, Joe Schilling, acted in self-defense and was immune from civil lawsuit under Florida law. But before we get into this video, please be sure to show the Firearm Firm channel some love by hitting the like button. And don't forget to click on the subscribe icon located in the bottom right hand corner of this video to subscribe to the Firearm Firm channel. Now, back in June of 2021, professional mixed martial artist and Muay Thai kickboxer Joe Schilling was out with a friend eating dinner at a restaurant down in Fort Lauderdale, Florida, when he was forced to defend himself against a heavily intoxicated and boisterous Justin Balboa. Balboa had gotten the attention of Schilling and his friend along with many other patrons of the restaurant due to the level of his intoxication and behavior. In fact, prior to the incident between the two, Balboa had gone over to Schilling's table and began talking to them even though he'd never met them before. Eventually, Balboa was asked to leave the table and he did comply. Later in the night, Joe went outside the restaurant to smoke. While Schilling was outside, his dinner companion began recording Balboa dancing at the bar and interacting with other patrons. Unbeknownst to her, at the time she started recording, she ended up recording the entire incident between Schilling and Balboa, which ultimately became crucial in the lawsuit against Schilling. Now let's take a moment and watch that video, and then we will come back and break down the law and discuss why the lawsuit against Schilling was dismissed. As you could see from the video, Balboa flinched like he was about to punch Schilling, and Schilling reacted in lawful self-defense. Florida Statute 776.012 allows an individual to use force against another when and to the extent that person reasonably believes that such conduct is necessary to defend themselves against another's imminent use of unlawful force. Furthermore, Florida law does not require the individual defending themselves to retreat before using force. In other words, the individual defending themselves can stand his or her ground. Now, some people believe that before you can use non-deadly force in self-defense, the other person must physically touch you, but that's just not the case. Florida Statute 776.012 uses the term imminent use of unlawful force, which means the aggressor doesn't have to actually strike or touch you before you can use force to defend yourself. It just means that the attack is about to happen. Looking at the video, you saw Balboa did not physically punch Schilling, but instead made a quick, sudden movement, acting like he was about to punch him. Whether he was actually planning on hitting Schilling or just trying to make him believe that he was going to is irrelevant. The question is whether Schilling reasonably believed he was about to be punched. Unfortunately for Balboa, Schilling was quick to react to the imminent threat of being punched, which left Balboa unconscious on the floor. One important thing I want to point out is that Florida law does allow you to use force to stop the imminent use of unlawful force by another, but once that threat has been neutralized, you are no longer going to be justified in continuing to use force. Now, that's exactly what happened in this situation. Once Balboa was on the ground, Schilling walked off. Now, many of you are probably scratching your head thinking that the video you just watched of the encounter was a textbook perfect example of self-defense, and I agree with you completely. So why did Schilling get sued? It's simple. Anyone can sue you for anything. The cops did come to the scene and interview Balboa, but no criminal charges were ever filed against Schilling. Instead, Balboa, knowing who Schilling was, decided he would personally sue Schilling and the restaurant where the encounter occurred, and that's how Katz and Phillips PA got involved in the case. Although Schilling knew that the lawsuit was just an attempt to get money out of him and did not have any merit to it, he was forced to defend against it. So remember, if you ever get served with a lawsuit, no matter how frivolous it might be, you must answer or risk the other person getting a judgment against you for your failure to respond to the suit. So we got involved in the case, started preparing Schilling's defense, and we immediately filed an immunity motion and refused to participate in the lawsuit until after the judge ruled on our immunity motion. We use the protection of Florida's immunity law to shield Schilling from having to answer the complaint or participate in discovery process beyond what was needed to conduct the immunity hearing itself, even though the lawyers for Balboa argue that we should be required to answer the complaint and participate in the full discovery. The judge agreed with our position. Under Florida Statute 776.032, a person who is justifying their use of force is immune from criminal and civil prosecution. Florida Statute 776.032, titled Immunity from Criminal Prosecution and Civil Action for Justifiable Use or Threatened Use of Force, in relevant part reads, Number 1. A person who uses or threatens to use force as permitted in Section 776.012, Section 776.013, or Section 776.031 is justified in such conduct and is immune from civil action for the use or threatened use of such force by the person, personal representative, or heirs of the person against whom the force was used. Subsection 3 of that statute reads, the court shall award a reasonable attorney's fees, court costs, compensation for loss of income, and all expenses incurred by the defendant in defense of any civil action brought by a plaintiff if the court finds the defendant is immune from prosecution as provided in subsection 1. After 2 days of hearing on our motion for immunity, the court determined that Schilling was justified in his use of force against Balboa and dismissed the lawsuit against him. In the order finding Schilling immune, the court also found that Balboa will have to pay Schilling's reasonable attorney's fees, court costs, compensation for lost income, and all expenses incurred by Schilling in defending the lawsuit brought Balboa. I don't know about you, but I sure wish I would have been there when Balboa's attorney had to explain to him that he was on the hook for paying all these fees. As always, if you have any questions about this video, the law of self-defense, or any other Second Amendment related question, be sure to leave them down in the comments section or email them directly to us at questions@thefirearmfirm.com. Until next time, stay armed and educated.